Welcome to Copyright Law for Artists. My name is Brian Hodge. I'm the Executive Director of the Printing Museum here in Houston. We strive to ignite creativity, foster hands-on self-expression, and be champions of print culture. We offer guided tours of our permanent collection galleries. We have 4 book art studios where you can learn papermaking, letterpress, printing, printmaking, and bookbinding. We offer a robust calendar of workshops, which you can find along with other of our programs at printingmuseum.org. Today, we are joined by Erin Rodgers, a partner with Rodgers Silvera, a full-service entertainment law firm concentrating in business counseling, intellectual property, contracts, civil litigation, licensing, and financing. Ms. Rodgers has been practicing entertainment and nonprofit law in the Houston area since 2007. She holds a bachelor's in music business from Loyola University, New Orleans, and a JD from the University of Houston Law Center. She has spoken at many entertainment industry events, teaches copyright and business courses at the Art Institute of Houston. She served on the Texas Entertainment and Sports Law Council and is a member of the National Academy of Recording Arts and Sciences. In addition to practicing law, Ms. Rodgers is a classically trained clarinetist and also plays the piano, accordion, and guitar. She has performed as a vocalist with Dave Brubeck and the Louisiana Philharmonic Orchestra, and currently performs with Houston indie rock bands, the Wheelworkers and Glass the Sky, as well as several other groups around town. I'll now hand it over to Ms. Rodgers.
Hello, good evening. I'm happy to be back for a rerun of this event. I had a lot of fun last time. Also, this is extra fun for me because I took this semester off of teaching, so I haven't got to do anything like this in a while, and I miss it. So I'm happy to be here. I am going to share my PowerPoint with you guys, and I will also send a copy, and I know this will be on video as well, so you're welcome to refer back to that information. So pardon me while I figure this out. Okay, there we go. Is that looks good to everybody? Are we good? Okay, cool. So yeah, my contact information is on here. Okay, so we're just gonna jump right into it. Copyright is something that I'm really interested in, and I hope that that comes across and that you guys are interested, and I'm happy to answer questions. As Brian mentioned, there will be a Q&A at the end, but I'll also stop a couple times, and feel free to put your questions in the chat. I enjoy answering questions, and I'm happy to tailor the information to whatever you guys need from me. But let's get started. So a copyright is actually 6 different rights. It's a bundle, we call it the bundle of rights. And that's important to know because if you have copyrighted material that somebody wants to use, you don't necessarily need to give them all of these rights. And vice versa, if you wanted to use someone else's copyrighted material, you don't necessarily need all of the rights that they have either. And that can be useful when you're trying to get permission from someone to use something or give someone permission to use your works. So those rights are the right to reproduce, which is the right to make copies. That's the obvious one. The right to make derivative works, which we're going to talk about a lot more. And that's probably one of the most important ones and probably one of the ones that this crowd is using the most. The right to distribute the copies, also pretty obvious. The right to public display and public performance, those are sort of the same. They just sort of depend on the media that you're using. And the right to perform via digital audio transmission, which is one that they tacked on in the late 90s, early 2000s to cover the fact that we now have streaming audio, downloadable audio, and it didn't really fit under any of the other categories. So that one's really specific. So mostly those first 5 are the ones that we're dealing with. You can copyright original works of authorship. So let's break that down. Original just means original to you. It doesn't mean the best thing ever written or the most creative work ever created. Other kinds of intellectual property have different standards. So for example, with a trademark, it has to be something nobody else has registered right now, and it can't be generic. With a patent, it has to be something nobody else has ever registered before. It has to be new. With a copyright, that's not necessarily true. No one at the Copyright Office is reading your work and deciding whether or not it has any sort of literary value or whatever, just that it is yours and you didn't actually mail in a DVD of a Disney movie and say that was a film that you created. You cannot copyright an idea, which we'll come back to. And that's why you see so many movies or TV genres, et cetera, that are similar, because you can't protect your concept, just your actual creation. So you can protect your version of that work. And authorship means any published or unpublished literary work, artistic work, architectural work, a photo, a film, an animated work, a poem, pretty much any creative work you can think of falls under copyright, as opposed to a trademark, which protects your business name or your logo, or a patent, which protects an invention or a method. Okay, so who owns a copyright? That question is sometimes simple and sometimes more complicated than you would think it would be. And also something that's a little bit contentious. A lot of my work is in the music world. So I'm going to give some examples from that universe, because as a musician and also a lawyer for a lot of musicians, that is where I deal with the most copyright issues. But it's also a good way to illustrate some of these things, just because musicians collaborate a lot more than potentially visual artists or something like that. So the obvious answer is the creator or the creators of the work. If I had my guitar in here and I sat here and created a song right now and recorded it on my phone, then I own the copyright in that work. That's easy. If I work on something with someone else, so if I was playing the guitar, but my friend was making up lyrics and we wrote a song together, we now have a joint work that we both own. And I'm going to talk about that more separately, because that is one of the biggest areas of A, misunderstanding of the law, and B, misunderstandings between people when they create works together. So that's an important one to understand, what you're actually getting into when you're creating something with someone else. So put a pin in that one. A contract holder. So intellectual property rights work like any other property rights. I can sell them to you. I can sell you my copyright. Now you have it and I don't. I can license it to you. Now you can use it for a certain thing. And that's where those 6 rights come in. There are certain instances in which it's pretty standard for something to be transferred. Example, in the music publishing world, almost always when a musician signs with a music publisher to control their songs, they give the publisher the copyright in their songs. That's pretty standard. But then there's other media where that's not normal. So it just depends on where you're working and what you're doing. And then a work made for hire is also something really important to understand that we're going to come back to. I've got separate slides on that. But a work for hire comes up when you have an employment relationship and someone is hiring you to create work. And that doesn't necessarily include commissions, or when you have a contract up front as a commission that says that it is a work for hire. And this is another common misunderstanding. Paying someone to do something doesn't mean you own it unless you also have paperwork saying that that's true. So going back to my music example, say I'm actually going to the studio tomorrow to work on a new project. So if I were to bring in a guitar player to play a part on my new song, and I gave him $500 to do that, but I didn't have him sign anything, technically that's a joint work and he still owns a part of my recording. I have to have him sign something that says that he doesn't. So just because I paid him doesn't make anything change. And the opposite of that is also true. You could have a work for hire contract where I could say, hey, guitar player, I don't really have any cash right now, but I'll buy you dinner and I'll put your name on my album and I'll make sure you get credit. So will you come play guitar anyway? And if we still have it in writing and there's some sort of trade, it doesn't have to be money. There could still potentially be a change in ownership there. So money doesn't have anything to do with copyright in either direction, is the point that I'm trying to make. And that is a common problem, especially in the music universe, where people say, but I paid the saxophone player, it's mine now. Not necessarily. Okay, going back to joint works. This is working on something together. And again, I'm going to illustrate this using music, but this could be anything. This could be 2 authors working together to collaborate on a book, or a group of filmmakers making a documentary film together. It doesn't matter. It's anytime you're working with someone else, and you're each contributing something copyrightable independently. So what I mean by that is, say I've written an entire book and I show you my book and I say, can you proofread this for me? And you do, and you just change a couple words or fix a couple typos, or say, it'd be better if you said June instead of July. that's not a copyrightable contribution in and of itself. So you do not have an interest in my copyright now just because you struck a few words or made a couple tiny suggestions. On the other hand, if I wrote the whole book and I give it to you and you're just so inspired that you write another chapter, even though I wrote 15 chapters and you wrote one, we now own the copyright in that work together. Of course, I have to accept that. I can't have given it to you to edit and you just decide to do that. But if I was like, yeah, cool chapter, and I add it into the book, we've got a joint work. So that's the second point, is that there has to be intention to make a joint work. If I find a poem online and I write a song based on that poem, that's not a joint work because the poet never meant for me to do that. It was just a poem and the poet's idea, the work was done and I took it and made it into something new. That's different. But if I were to write a piano track and say, someday I'm going to find somebody to write some lyrics for this, and then 5 years later I do, and you write lyrics to my existing piano song, it's still a joint work at that point because we meant for that to happen. So why does that matter? If you're getting into a joint work with somebody and you don't have something in writing, everyone involved now owns the copyright equally, even if the contributions weren't equal. So even though I wrote 15 chapters of the book and you wrote one, technically under the law, we now own it 50-50. We can make up whatever we want in writing, and that sort of document does not have to be very long. It could just be, on this day, we completed this book. It's tentatively called this, and we've decided that it's fair to split it. Erin 90%, Brian 10%. Erin has control over publishing, but we'll always pay Brian his 10%. Whatever deal we want to come up with. But if we don't do that and we just work on the book together and don't have anything in writing, then it's equal. And also, either of us can do anything with it, not exclusively. I can't go sell it to somebody, but I could license something to somebody and I just have to pay you your portion. So if I have 90% of the book and Brian has 10%, I could go license it to Disney to make a film out of it. And now I get 90% of that and Brian gets 10% of that, but I don't have to tell him that I'm doing it or ask him. And the problems that come up with that are, well, particularly again in the music world, maybe somebody wants to put my song in a commercial for a brand or a product that I don't particularly approve of. And my co-writer is like, yeah, sure, whatever, do it. And now my song is in this commercial I don't like. Or maybe my collaborator is a brilliant artist, but doesn't know anything about the business. And Steven Spielberg says, I'm going to give you $100 to put your song in my film. And my co-writer says, yeah, sure. And I'm like, we should have gotten $10,000 for that. What were you doing? So that's why it's a good idea to get this stuff in writing. You also can't take your own work back after you've created a joint work together unless you agree that you can. So for example, on that point, I had a client one time who wrote a musical together with another writer, and then they got in an argument. And the second writer said, I don't want you to use any of my lyrics that I wrote anymore. And it was a joint work. And he asked me if he had to remove her lyrics. And I said, well, you don't. And he said, well, I don't really want to use them anymore because now there's bad blood. I'd rather just get someone else to write new lyrics. So he did, but he couldn't deny the fact that she owned half of the song. So he still had to pay her half and give the new lyricist some of his money to still use the songs, even though he had not used her words. So if you're working with someone else, just go ahead and talk about what the splits are going to be and how you're going to handle everything when you're done with it, while everyone still likes each other before money is happening, so that you can remember what happened and who contributed what and how you want to split that up. Works for hire. So again, this one is also super important and something that you will see a lot, and something that there is also a lot of misunderstanding about. So works for hire can come up in two ways. First of all, you are an employee somewhere, not necessarily a contractor, but an employee, and it is your job to create creative works. So if you are a graphic designer for Target, and that is your job, Target is going to own everything that you do as a work for hire. It's just a given. You're not going to be able to take those designs and do something with them somewhere else. Target is the author of those works from the beginning of their creation. It can also come up in a contract, but it has to be before any work is done. So if you're making a book and you want to hire an illustrator and you want it to be a work for hire, before the illustrator puts pen to paper, you would have to give them a contract that says, this is a work for hire. I'm paying you this much. I'm going to pay you 10% of sales, whatever you want to do. It could be a flat fee, it could be a royalty, but it's a work for hire, meaning you own it and that illustrator doesn't own anything. So that's not necessarily a good or a bad thing. It's just something to understand. So in the film universe, for example, you've got sometimes hundreds or thousands of people working on one project. It would be a mess if all of them owned a part of the copyright. Anytime you wanted to get distribution, you'd have to get 1,000 people on board. So it makes sense that all of those things are a work for hire. And anyone working in that industry just sort of understands that I'm an editor, I don't own anything. It's a work for hire for the film production company. But if it's something more like, again, going back to me hiring the guitar player to play on my album, we want to be clear about that, I'm happy that you're contributing to my song. I'm going to pay you. It's a work for hire. I own the copyright in my song. I will pay you something. I will put your name on the album, whatever, but you don't own anything. So just make sure that you understand what you're giving up when you do that. Or on the other hand, if you're having people contribute to something you're doing, to potentially have them sign work for hire agreements with you so that you own everything. And that, again, isn't necessarily a negative thing. It can make it much easier for you to do something with the work when there's just one owner. So also, if you work for a school or you go to school, the school tends to own anything that you do. So just be aware of that. My Art Institute and HCC students are always surprised to hear that the music they make in the studio actually belongs to the school and not to them. So check your employee handbook, check your student handbook if you're a student. But that's just an FYI. Okay, next topic. When is a work copyrighted? So congratulations, all of you already have copyrights, whether or not you ever registered anything. So that's good news, I hope. You have a copyright as soon as something is fixed in a tangible medium. So as soon as if I'm just sitting here playing the guitar and singing into space, I don't have a copyright on that. But if I hit record on my phone or on my laptop, or if I get out a piece of paper and write down the lyrics and the melody, I now have a copyright on that. So that's all that you have to do. There is nothing that you have to do to register to have a copyright. We're going to talk about why you should sometimes register the copyright anyway, but you don't have to have a copyright in it. Just to be extra clear, any sort of thing that you're doing electronically is going to have a file stamp information in it. So you're going to have the record of when that was created if you ever need to prove it. If this is something that you're writing by hand, you can just put copyright and then the year. Obviously, don't put 2021 because it's 2022. But whatever you need to do, just write it on there. And if you're a visual artist, I know sometimes there's a hang up about having a date on the artwork because it may not be in a gallery for several years until you're finished with the series or whatever. Then you can just take a photo of it and that will be file stamped and then you'll have some proof. Don't mail it to yourself. That is a legend called the poor man's copyright. And the theory there is that if you write something or paint something or whatever, and you mail yourself a copy and you don't open it, then the postmark will prove the date of creation. And there may have been a point before the 70s when that might have been helpful, but these days that is not useful because you already have a copyright just by having done the thing. So either register it or don't. That doesn't help you any more than just having written it down in the first place. So why should you register your copyright if you already have one? There's a few reasons. The most important one from my perspective most of the time, well, the first two really, if somebody is infringing your copyright and you have not registered it, all that you can go after them for is what you can prove that you lost, so actual damages. So if somebody steals my album and sells one copy for $10, I can sue them for $10. That's not super helpful, even though they took my stuff. And there's a lot of stuff that's really hard to put a dollar value on. So, I mean, that's an obvious one. If I have a product and it sells for a certain dollar amount and you've made one copy, we know how much that was. But use online, et cetera, can be hard to establish what it even was worth. If you've registered your copyright, you automatically can get statutory damages between $750 and $30,000 just because somebody did it, and $150,000 if you can prove that they knew better, which if you wrote copyright 2022 on the front of the artwork and then they stole it and used it, that already proves that they knew better. So you don't even really have to do anything else there. I am not a litigious person. I will sue someone if someone hires me and that's what they want me to do, but I try not to. But this is still a better way to negotiate than if somebody knows that you could, than to go after somebody for $10. Because you could say, I could sue you for $30,000, but what I really want is for you to actually collaborate with me, or for you to give me credit, or whatever it is that you actually want, or for you to stop, don't do this anymore. It just gives you a negotiation point to start from if you have that financial threat there. Something else new that has happened that we might have talked about last time, and I actually haven't heard anything yet about the status or how this is going or anything, is that they started a copyright small claims court, which is through the Copyright Office, where historically speaking, if you did want to sue somebody for copyright infringement, you would have to go through the federal court, and that's expensive. Getting a lawyer that's licensed in federal court typically costs more. Filing a lawsuit in federal court costs more than regular court. So a lot of people knew they could just get away with stuff because no one was ever actually going to go after them. So now there is this small claims process where you can go after smaller copyright claims, and it's essentially like an arbitration panel. And it's going to be interesting to see how that pans out, because I think I can see pros and cons of it. I mean, on one hand, as a smaller content owner, if your work is infringed in the past, there really wasn't much you could do about it, and now there is. On the other hand, it'll be interesting to see if there's a bump in like arbitrary infringement cases or questionable infringement cases. So we'll see. Anyway, moving on. Another reason to register is that somebody can find you because there's a Copyright Office database. It's not a great database right now, but they have been gradually updating their website and their database to make it easier to maintain. So I have used it as a lawyer before when somebody's come to me and said, I want to use this person's photo in my book. How do I find them? How do I pay them? And through the Copyright Office database, I can track them down, email, call them, send them mail, whatever, and get them paid for that use. And also, it's just easy. It is not that hard to register a copyright. I can help you, Tala can help you. Honestly, if it's a basic copyright, like you made a painting yourself and that's it, you can do it yourself. You don't need a lawyer to register a copyright unless you get into it. Well, you never technically need a lawyer to register a copyright for you. You can sign in and do it yourself. If you're getting into complicated issues where you've got samples or you're using somebody else's work in your work, or there's 12 collaborators and one of them's in Spain or whatever, then maybe you want to talk to somebody and you need some help at that point. But there's no technical reason why you can't register a copyright. And I wouldn't advise anyone to try to register a trademark or a patent by themselves because those are more complicated, but copyrights are just relatively straightforward. Hold on, I clicked away from my thing. So you register at copyright.gov. And these are the forms that are most relevant to us. The standard form is $65, and that's for works that were published together or for a single work that doesn't qualify for the single work by single author form. So for example, published together would mean if you put out a book of poetry and that book has 20 poems in it, you could put all of those 20 poems together on that same application for $65. This is relatively new, the group of unpublished works form. It used to be that you could put as much unpublished stuff together on the same application as you wanted. Now you can't, you can put 10 works at a time. So if you haven't published your poems yet, you've got 30 poems, you could do 10 at a time for $85 each. And then the single work by single author form, that's $45, but that only applies if, well, obviously single work, but single author also means that you're copyrighting it under your own name. So if this is a work for hire, or if this is something that you're copyrighting in the name of an LLC that you own or something like that, then you won't be able to use that form. But if you're just using your own name to copyright one work, that's $45. The process, I don't have it on here. The process has actually surprisingly sped up during the pandemic. It used to take about 6 months for them to process an application. Now it's taking about 3. So I don't know what they did, but it's awesome. And the date on your copyright registration will be the date that you submitted everything. So if you submitted it tomorrow, even if they don't send it to you until May or June, the date on your registration will be February. So it doesn't matter that much that you're waiting for it. We talked about that. Okay, a copyright lasts for the life of the author plus 70 years. So it's a really long time. If you have a joint work where there's two people working on something, it is the life of the person who lived longest plus 70 years. A work for hire lasts 95 years because it wouldn't be fair for a company to keep something forever if they just never dissolved and the same company exists for hundreds of years. Copyright is supposed to be a balance between protecting creators and letting them get paid for their works, and between the interest in the public having access to their culture and the right to build on that culture. So I still think these numbers are kind of long personally, but at least they do eventually end. And this is under the 76 Copyright Act. So anything older than that has different protection periods, and it is possible. Back then you had to renew certain things. There were periods in which you had to renew a copyright. That's not true anymore. So typically speaking, and I didn't update this, public domain currently is 1926 or older. We gain a year of public domain every year. So as of 2022, 1926 and older is public domain. But there could be things newer than 1926 that are in the public domain because of other reasons. People didn't renew them, et cetera. Hold on. Okay, yeah, let's stay there. Okay, jumping around. I said I was going to come back to derivative works. So this is probably the most important of the 6 copyright rights to understand, because the right to make copies and the right to distribute it, the right to display it, those are all pretty obvious. But the derivative works right is one that is used a lot and one that is often misunderstood about what you can and can't do. So a derivative work is anything that is based on an existing work or works. So for example, a translation of a book, the translation would be a derivative. A collage where you've taken a lot of different artwork and made it into something new, or a mashup song where you've taken 2 or 3 songs and put them together. A motion picture version of a book, anything like that. Taking a photo and making it into a painting, that would be a derivative work. So anytime you're taking something that already exists and making it something new, that's a derivative work. You have to have permission to make a derivative work, technically, unless it's fair use, which we'll get to. And if you do have that permission, your copyright only extends to what you created. So for example, if I wanted to make a film version of a book that is still in copyright, and I got permission from the author, I could do that. That doesn't necessarily mean I can stop any other filmmaker from making their own version of that book into film, unless the contract says otherwise, which is a separate question. Or a translation, just because I got to translate your book into French doesn't mean I can stop somebody else from translating it into Spanish. They just can't use my French version to do that with. So, and in order to have a copyright in it at all, again, what you did to it has to be original enough to justify there being a new work. And it also doesn't change the copyright in the underlying work. So if I wanted to write a new version of a Shakespeare play, I could have a copyright on my new version of that Shakespeare play, but that doesn't put Shakespeare back into copyright. Shakespeare is still public domain. So anyone else can go do anything else with that play. I can just protect my own version. And just to compare that, there's a lawsuit, the Lee case, where a store owner cut up Hallmark cards and glued them to coasters, did not do anything else to it, didn't draw on it or add any other additional elements, just literally cut up cards, glued them to coasters, and got sued. And she won because it wasn't a derivative work. She owned those cards. She purchased them herself. They weren't copies. She didn't infringe anybody's copyright. She bought the cards and she just cut them up and glued them to something else and didn't change them in any way. So that wouldn't be a derivative work. It would be different if she had made collages out of them, or if she had photocopied the cards before she glued them, then she would be infringing their copyright. But a derivative has to be something that you added to the work. So that's the basics of what you own, what your rights are, and how you protect them. But let's talk now about if you wanted to use someone else's stuff or someone wants to use your stuff, what does that look like? So in the US, There is no excuse not to have a license unless something is fair use. Other countries have something called orphan works policy that lets people, under varying circumstances, depending on the country, use other people's works if they cannot get in touch with the owner. We, in my opinion, unfortunately, do not have that because copyright lasts so long. So the problem that you can run into is maybe you want to dramatize a book that was written in 1945. The author is dead, his children are dead, the grandchildren don't know what they have, you can't get in touch with them, you decide to do it anyway. No matter how many times you tried to call and how many letters you wrote, if one of the grandchildren finds out that you did it and figures out that they own the rights to that book, they can still come and sue you later. And there's no, it doesn't matter how hard you tried. Of course, the judge might care and make the damages a little lower, but there's no getting out of that. So you do need a license for anything that you do, unless it's in the public domain, which again is 1926 or older, or it's fair use. Well, let's go back. So if you are trying to get a license from someone, the things to be specific about are you paying them a flat fee, or are you paying them some percentage of whatever you're going to earn? So if you're licensing somebody's artwork to put in a book, are you just going to pay them $500 and call it a day? Or are you going to pay them 10% of whatever you make from the book, or some combination of that? Maybe you're going to pay them $250 and then 5% of whatever you make from the book. There aren't really any set terms on how much licenses have to cost, except in a very specific instance for licensing cover songs. That's the only one where there's a set price and set by the government, and that is it. But for everything else, the owner can say, no, I don't want you to do that. Or they can say, sure, you can do it for free. Or they can say, yeah, you can use my photo, that'll be $1 million. It's entirely up to you. And of course, there's industry standards about what these things cost and how long these licenses last. But that's negotiable, and there's no promised terms that you have to agree to. But let's talk about fair use. So fair use is the exception to needing a license. And there are 4 factors that the court uses to decide whether or not something is fair use. The great thing about fair use is that it lets you use other people's work as part of yours if it falls under certain reasoning. The bad thing about fair use is that it's only a defense. So you can get a lawyer's opinion up front about whether or not something is fair use, but unfortunately you have to go to court and get sued for copyright infringement and then defend yourself with fair use in order for it to actually be effective. It's not something that is proactively very helpful. So winning a fair use lawsuit can still be expensive. You still have to go to court to prove it. But anyway, the 4 things that we use to determine whether or not something is fair use, and this is what we call a balancing test. So this is not a checklist. These don't all have to be true, are the purpose and character of your use. So the more that you are on the educational nonprofit side, the more likely it is to be fair use. It's not automatic, but more likely, as opposed to a very commercial use. So my using some photos in a history book is going to be more likely to be fair use than my using some photos in a pop music video. The nature of the work that you're taking is sort of the same question. Are you using historical photographs to make a point, to make an artwork, to make a documentary about some particular historical event? Or are you taking an original painting or an original song that is a commercially released product and using that? The amount that you used, there is no magical percentage. I've heard a lot of things. I've heard 10% of the work, or 3 seconds of a song, or 10 seconds of the film. None of that is true. There have been lawsuits lost over 2 notes being used in a song. But what the question here is did you take more than you needed to get your point across? So if you were making a parody song, for example, did you just take enough of the melody that somebody gets it and says, oh, that's that Beyonce song. Oh, you made it funny. Or did you take the whole beat out of the whole Beyonce song and then just put funny lyrics over it? That's not going to be fair use. You can't take the whole thing, just enough for somebody to get the reference. And then probably the most important one is the effect of the use on the market for the original work, which means, will people buy your version instead of the original, or are the 2 things different enough that it doesn't matter? So I'll run you through an example. The lawsuit where this came from actually was Two Live Crew, the rappers, were sued by Roy Orbison over the song Pretty Woman. So Two Live Crew has a song called Pretty Woman, which starts out referencing the Roy Orbison song and quickly becomes something else, but it does use the chorus melody and the chorus lyrics. So in that lawsuit, which went to the Supreme Court, the judges created this framework essentially to decide that in fact Two Live Crew's work was fair use. And they determined it this way. So purpose and character of the use. This is not in Two Live Crew's favor. It was a commercial use. It was a commercially released album. It was not for profit or documentary or something like that. The nature of the work, still not looking good for Two Live Crew because Roy Orbison's song Pretty Woman is again a commercially released song and they weren't making some sort of historical or educational commentary on it. Maybe one could argue that, but I'm not going to make that argument. The amount of the copyrighted work used. So this is where things start to turn around from them. Their song is not a cover of Pretty Woman. It just takes enough of the song that you get the point that they're referencing this song, and then they make it their own. It's very much their own style. The lyrics are different after that initial intro. It does not sound like Pretty Woman after the first 10 seconds or whatever. But maybe most importantly, the effect of the use on the market for the original. So the question here is, are people going to stop buying Roy Orbison albums because Two Live Crew put out their song Pretty Woman? And the answer is no. It is not the same song. It is not the same target market. It is not just a cover that is a substitute for the original. And that is where it is turned around and they won this case. So some examples of things that are fair use, quotes or excerpts of works in a review or criticism. So if you wanted to have a YouTube channel where you review films and you show various space lasers and comparing, like, look at the space laser technology in Star Wars versus Star Trek or whatever, you could do that as long as you were commenting on it and doing some sort of criticism. A parody, which is very specific. A parody requires that you are making fun of the thing that you took. So you could probably argue that Two Live Crew was making fun of Pretty Woman as well in that case, and that could be a parody. But just taking somebody's lyrics or music and writing funny lyrics to them is not necessarily a parody. It has to be somehow poking fun at the original. Or not necessarily funny, but commenting on the original, making some sort of social commentary. Reproduction of part of a work by a teacher or student in a lesson. So if I'm giving a lecture at the Art Institute and I want to show a piece of artwork because it's relevant to what we're talking about, I can do that. Or if I want to copy 2 pages of a book so that my students have this one article, I can do that. I can't copy the whole book, but I can take little pieces of things. Incidental reproduction, which would be like if the news is filming somewhere and there's artwork in the background, they don't have to clear all of that artwork from all of the artists because it's just incidental. It just happened to be in the background. And another one that goes on here is government works. So anything that the government created, there's no copyright in that and you can use it. I've used some NASA recordings to make beats for my songs. So I can take those. So we talked a little bit about using someone else's work. If it's not fair use, you do need a license. So ways to find people, copyright.gov. Again, their database is not perfect, but they're working on it and it's better than nothing. If you're looking for music, ASCAP and BMI are the place to go. I use, when I'm trying to track down either film companies or book publishers, usually Amazon. Pretty much everything is on Amazon. Even if you don't want to shop there or use it, you can at least use it as a database to find that information. So that's the most extensive way to find books and films that I have found. Again, we talked about that you don't have to necessarily give somebody else 6 of your rights, and that there's no legal excuse for not having a license, and there's no minimum amount that is exempt. What if someone is using your work and you don't want them to be? As I mentioned, that's a federal lawsuit, and then there's also this new Copyright Claims Board. The things that you have to show, though, we haven't talked about that yet. If you think someone is infringing your work, you have to show 2 things: that they had access to it and that they're substantially similar. So access means what it sounds like, that maybe your work was online somewhere and you can prove that somebody could have seen it on your website, or your art was on display at the printing museum. Somebody could have come in and taken a photo of it and that's how they found it, that they had access. If you painted a painting in your house and it never left your living room, and it's COVID, so no one's been at your house in 2 years, and somehow someone in Michigan paints a very similar painting, they did not have access to your work. So no matter how similar your works are, that's not infringement. Copyright can be pretty weak in that way, that you could create a very similar work to someone else, but if you didn't have access to their work or they didn't have access to your work, there's no infringement there. And substantial similarity, that's always the difficult question. And that's where you get the experts in the court trials trying to explain whether or not something is substantially similar to something else. There are, of course, cases when it's really obviously similar and cases when it's really obviously not. But there's a lot of stuff that falls in the middle. For example, there are a ton of lawsuits against Bruno Mars. If you're familiar with Bruno Mars, Uptown Funk, there's a lot of lawsuits suing him and his producers for Uptown Funk. And some of them, you listen to both songs and you're like, yeah, I see it. Those songs are very similar. They probably were best case inspired by those, worst case, maybe that's infringement. And then there's others where you're like, just because both of you are playing the bass with the same funk bass tone doesn't make that infringement. And there is some questionable gray area in the middle. So it can be hard to prove that. What you don't have to prove is that someone meant to copy you or that you meant to copy someone else. The court will take that into consideration if they believe that you didn't mean to copy somebody, but that's not really enough. And I know as a songwriter, a thing that happens to me a lot is I'll come up with a great melody and I'm like, I'm so brilliant. This is the best melody I've ever written. And then 2 days later, I'll be like, oh, that was Duran Duran. Oops. Like, you're just not even thinking about it. And, that's still infringement. It doesn't matter that I wasn't consciously ripping off Duran Duran when I wrote the melody. But if this does happen to you, the first step is usually to write a cease and desist or a demand letter to just try to resolve it. Say, hey, don't know if you knew that was my photo that you took and are using on your book, but you didn't ask me, and I would appreciate it if you would stop / pay me something / give me credit, whatever it is that you want, like we discussed before. And if that doesn't work, you do have to go to court to enforce it. I will say that historically, most copyright demand letters don't go anywhere because people have known that most people aren't going to go to federal court over it, but that may be changing with this new system. We already talked about that. Also, most of these lawsuits settle because being in federal court is super expensive and nobody really wants to be there. And also a lot of times the bigger companies don't necessarily want all of the information about their income for these works to be public. So a lot of times you'll hear about a big copyright lawsuit and then you just won't hear anything else. And that's because they settled privately. If somebody's using your work online, we should talk about that. There's a specific way to deal with that. It's called a DMCA takedown notice, and that protects the service provider. It's sort of the way you have to go though. But that doesn't stop you from going after the person who posted it. So for example, I have a photographer client who has a wedding photo that got sort of popular and became sort of a viral wedding photo. And for a while there, we were just issuing like constant takedown notices. But there was a law that was passed to protect service providers and companies like YouTube, et cetera, from infringement as long as they participate in instantly taking the stuff down once they're notified that something is infringing. So her photo kept popping up on BuzzFeed and stuff like that. So we would there's a process to tell BuzzFeed, hey, this photo you didn't have permission to use it. They'll take it down pretty much right away. You don't necessarily get anything out of that, but it's pretty easy to get it taken down. But you can still go after the person who posted it. So like on YouTube, if you tell YouTube this video is infringing, YouTube will take it down. But you can still go after the person who posted it for infringement if you wanted to. We talked about that already. We talked about that. Enforcement. So copyright, unlike trademark, in which you are sort of obligated to enforce your trademark, you are not obligated to enforce a copyright. And there's also no copyright Santa out there watching your copyrights for you. So you have to stay on top of it if you want to enforce it, or you can also decide not to. And I'm sure you've heard about this throughout the years of people or estates that are especially litigious about people using their music. Metallica is sort of historically the butt of those jokes because they just sue everybody for everything. There was an Onion article that was like, Metallica sues 9-year-old girl for drawing their logo on her school notebook. It's not that far off. Disney is another one. They sue everyone for everything. They sued a daycare for painting Mickey Mouse on the wall. It wasn't even a good painting. But then there's other people who just, are happy for you to use their works, don't care so much. I know there's bands that will let you tape their concerts and swap tapes, and everyone has a different opinion about it. So you can do what you want, but it is up to you to enforce the copyright and to know what you're getting into if you're going to use someone else's work and you do not get a license from them, that you're risking that they are going to come after you because that is their right. We talked about that. We don't need to talk about trademarks. And one other thing I want to touch on quickly, and then we'll take some questions. Yeah.
Asha John had a question about the difference between copyright and trademark.
Okay.
Just go over that again.
Well, let's go to that then. I won't skip it. So a trademark is specifically for something that is a brand identifier. So that would be your name. It could be your real name. If you're using your name and you're famous enough as an artist, you can trademark your own name as an artist. It could be your logo. It could be a slogan. It's anything that identifies your brand. So with Nike, for example, you've got the name Nike, you've got the swoosh, and then you've got Just Do It. Those are all Nike trademarks. And that's different than a copyright because a copyright would be the things that you're creating with that trademark. So my band name is a trademark, my music is copyrighted. And the things that make that different is because trademarks are tied to a brand, you have to continually enforce it and re-register it. A trademark has to be reinforced and re-registered every 10 years. So the first 5 years and then every 10 years. So 5 years, 10 years, 20 years, 30 years. You have to pay again and prove that you're still using it. You can't just hold on to a trademark for eternity because you came up with a good name, which is unfortunate because I come up with a lot of good names for businesses I'm never gonna have. But anyway, copyright on the other hand, because that is your creative work, you get to keep that for your life plus 70 years. But that's the difference. There can be some overlap. If you had, for example, a really complicated artistic logo, you might be able to trademark that as a logo, as your brand identifier, but you also might be able to copyright that as an artwork. That's not always true. So I mentioned Target earlier, for example, the Target logo, which is just the 2 red circles, they could trademark that. They probably couldn't get a copyright on it because it's not original enough. Copyright, even though I said it doesn't have to be brilliantly creative, it does have to be at least something that wouldn't keep other people from getting to use basic geometry. So you wouldn't be able to copyright that. But that's the real difference. Trademarks are also more expensive. I need to update this. It's actually $250 now. And also when you register trademarks, you have to specify the ways in which you're using it. So you would register by class. So for example, you might register as a restaurant, but someone else could have the same name for their dry cleaner or for their band, because those things aren't really overlapping. And there's 46 classes, I believe, 45 or 46. So you have to pay $250 per class that you want to protect it in. And you also have to prove that you're actually using it in those ways. So you have to send in photos. If you say you're making clothing, you have to send in photos of the clothing or send in a screenshot of the website where that clothing is for sale. And again, that's different than a copyright. You don't have to actually be using your copyrighted works. You can just write it down on a piece of paper and you have a copyright. That's not true with a trademark. You have to prove at some point that you're using it. You can file a trademark before you start using the name, but you only have so long after it's approved to start using it. So that's the difference. I hope that answered the question. And the only other thing I wanted to mention super quickly is Creative Commons, which is something to know about. And that is a nonprofit that lets people share their works with a free license, essentially. And they can put limits on those licenses. So it's not a substitute for copyright, but it narrows the scope of your copyright. So for example, if I took a bunch of photos and I just want you to be able to use them, I could post them under a Creative Commons attribution license, and then you're allowed to use them and all you have to do is give me credit. And that's a useful thing to know about, because not only for sharing your own work, if that's something that you're interested in doing, but like, for example, I've made show posters and stuff like that for my bands. where I've been able to find Creative Commons photos that I can use as a background. And then I just put the author's name on the bottom and say photo by whoever, and make sure that it's one that allows me to add text to the photo, that I can modify it. And I don't have to ask or pay anyone for that. And the photographer's works are spread. So again, that's something you have to choose and opt into, but it is a way to find works that you can use for certain things. If you're looking for stuff and you don't want to have to pay for a license from Getty Images or something like that. Okay, any other questions?
Okay, so the first question in the queue was about, and maybe Asha, you can ask this, because I'm not quite sure if I understand, but she asked, what if it's for a loved one who has deceased or art on a website? I'm not sure.
So if you're talking about inheriting copyrights, that does happen. You can pass somebody your copyright in your will. If you don't have a will, then it passes down the way the rest of your property would. So if you were married and you died, your spouse would then own your copyrights. And if that person died, then it would go to the children, and they would have the right to enforce it for 70 years after the person's death.
And then what about art on a website? I'm assuming it's a third party. Third party's art on the website?
Putting someone else's art on your website, you do need to license that if you're using it. And if your art is on someone else's website, you don't want it to be, you can ask them to take it down. And that goes for art or photography or anything else of yours. Somebody cannot use your work on their website without your permission, unless the only exception to that is you could embed something, like if it was embedded YouTube video that actually links back to YouTube so that that person is still getting paid for that usage. That's a slightly different scenario, but I can't just download somebody's photo and put it on my own website without asking, unless it's Creative Commons.
And then another question about the registration process. Do you pay $65 for each artwork? And if you use artwork on a t-shirt, you list it as copyright 2022 on the website.
Okay, so as far as is it $65 per work, that depends. So if you are creating artwork one at a time, and they are not all published together in a way that it would be a group publication, like a book or an album that has multiple songs on it, or maybe a DVD of short films, there's 10, you could put those together. Otherwise, yes, you have to register each work independently. If you are the sole author of that work though, so you're an artist, you made an artwork that's going to go on a t-shirt, then that would be the $45 form. Unless, again, you are trying to have your LLC own that artwork or something like that, in which case it would be $65 per application. And on your website, I mean, you don't necessarily need to put that under each work that it's copyright 2022. You would have your own rendering of it at home that, you know, and you could just put on the bottom of the website, like all designs, copyright your name.
The next question, how does copyright work for stock photos or graphics?
So if you're trying to use stock photos, you just need to be really careful about reading the actual terms of service, because a lot of times things that say royalty free are not. It will be royalty free as long as you're printing it out to look at it at home. So you need to be cautious about that and make sure that you're reading the terms and making sure that you are actually allowed to use those photos for what you want to do with them. Usually you end up having to pay for that. It's almost never actually free for stock photos, but most of them have a subscription service that lets you use it. Yeah, there's tons of images out there, but that is another place where Creative Commons can come in handy unless you're looking for a specific thing.
Okay, and I think the last question in the chat is from Gail, is my art on my website considered fixed in a tangible medium?
Yeah, and you can register that as well. And in fact, I haven't dealt with it, but they've been creating a bunch of new forms and new ways to register lately. And I want to say that there is a registration that has to do with things like blogs and stuff like that. I don't know if that's relevant to your particular needs, but I haven't done that form. But like I said, there's a bunch of new stuff. So there may actually be a way to make that easier now if you're posting a bunch of stuff. But yes, I would say that's fixed in a tangible medium.
Are there any other questions from the viewers?
So back to the stock photo thing real quick. So if you buy a stock photo and then someone were to use that photo to create something else, right? Like a drawing or something like that, does that give you the right to it, or how does that work?
Like if you wanted to use a stock photo to make something else, make a derivative work?
Yes, but you bought the rights to that.
Buying the rights to the work probably does not give you the right to make derivative works, but you would just want to check the terms of service to see if you were allowed to do that. But typically when you purchase the rights to use stock photos, that's just a license. So going back to your 6 rights, it's usually just the right to display. It doesn't usually include the right to make derivative works. So if it was an assignment where you're actually purchasing the copyright, then you could do whatever you want with it. But normally when you're purchasing stock photos, you're just buying a license to display it.
Okay, thank you.
Sure, good questions.
So, Erin, are you familiar with Shepard Fairey? How he used the Obama photograph? Can you explain a little bit about like why that was, why he got in trouble, essentially?
Yeah, so that was based on a photo. It was a derivative work, and it was not a transformative use. So going back to the 4 factors of a fair use, which was the claim that he wanted to make that it was fair use. Sometimes someone will summarize all of these 4 factors by just saying, was your use transformative? Did you take something and do something so different with it that it's essentially a new work? And in this case, the determination was that he did not, because that photo was similar. He colorized the photo essentially and added the language on it, but it was still clearly that photographer's photo. There was no question. It wasn't manipulated enough to make it different enough in the court's opinion to be fair use. That case went back and forth a lot with getting overturned, because I think it was a narrow enough question that there was some debate about that, because, you know, it is iconic and it is different, and it looks like a different style, etc. So there was some real debate in that case about whether or not that was fair use or infringement. But yeah. If you have more questions about that, not Shepard Fairey specifically, but fair use and where those parameters are, there is a website. I want to say CMSI. I'm going to Google it real quick while I'm here because I don't want to be wrong. Fair use. That has guidelines for all different media and like what the boundaries are. Yes. Okay. See, it's the Center for Media and Social Impacts. So CMSI. And they have useful guides for all different media about what is fair use and how to make a good fair use claim. And it varies, but yeah, the Shepard Fairey stuff is super interesting.
Are there any other questions? Well, we have hit the hour mark, so if there aren't any
Right on time.
we can end it here. Thank you so much, Erin, for again such an insightful talk on copyright issues for artists.
Well, thank you for having me back, and I'm always happy to answer more questions. My email was at the beginning of the PowerPoint presentation, and I'll talk to you soon, Brian, I hope, and hope to be back again. So,
well, thank you so much.
thank you. Have a good evening.